As promised to your lordships yesterday, I'll now, since my time is curtailed to 45 minutes, I'll stick to four. I'll stick to four judgments. What I've done in the meantime is
You got your note.
I've got three things done. The timeline that I gave to your lordships yesterday,
Yes.
the timeline I gave to your lordships yesterday, I've got a note made.
Yes.
The judgments with propositions that I'm relying on, I've got a note made. And the distinguishing note on the judgments relied on by the other side, I've got that note made. So let me just hand it over to your lordships. If your lordships permit, that may be easier, and then proceed with my argument.
All right.
Mr. Courtmaster. This is, my lords, the list of cases we are relying on. Please give one copy to Mr. Sidbal. This side. Then is Mr. Courtmaster. There are two more. Just take this. This is with the letter. So why are you giving me the letter? No. Just 2, 3, 4, 5. My lords, these are the judgments we are distinguishing. The ones I am now handing over are the judgments. Please give one to Mr. Sidbal. And lastly, what I am giving to your lordships is the timeline that I relied on, my lords, so that your lordships have in place.
That one place. You've circulated to Mr. Sibal.
Yes, my lords, absolutely. Each of them, as I hand over to your lordships, I am giving to. And my lords, this timeline I have consciously not included the EC events, because as your lordship said, that's not something that your lordships are getting into. I pretty much stuck to about the first week of July and stopped to the first week of July as far as these list of events are concerned. So my lords, these three things are done. And I have given now, my lords, let me straight away come to the 3 or 4 cases that I need to cite, and that's it. Let's keep the PDF page ready. But one argument, my lords, I just wanted to make before I go to the case law. My submission yesterday for your lordship's kind consideration was that this is an artificial distinction sought to be drawn between a legislature party and political party. It has never been our case at all. In fact, we've right through said that it has the political authority of the political party. They are organically and integrally connected, and they're co-joined, and they have to be seen together. That's how the framers of the Constitution always looked at it. And in fact, whenever an attempt is made to segregate, they say, no, we must look at both. Now, that is further fortified if your lordships were to have para 4 of Schedule 10, which is a defense. Of course, I'm not on the defense argument at all, because according to me, I have not incurred 21A or 21B. So I'm not on the defense at all. But please have that why they should be considered together, and one has a bearing on the other. Please have para 4
That's important point.
of the 10th schedule.
Para 4 of the 10th schedule.
Yes, my lord. May I, with your lordship's permission?
Yes.
A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party, and he claims that he and any other members of his original political party, and please have 2, for the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. So even when you come to a defense, the bearing of what happens in a legislature party, in fact, they say it's deeming. It's a deeming fiction there as far as the defense of merger is concerned. I'm not for a minute suggesting I'm coming under para 4. I'm just drawing analogy from para 4 to say what bearing does the two have on each other. So when you come and say that this is only in the legislature party, nothing has happened in the in the political party. My lords, even in Rana, which is one of the judgments I'll read out, when the defense was taken up of whether there is a split or not, the question was, should the split only in legislature party be seen or the split in political party be seen? Even there, the Supreme Court said, the speaker will not embark on an independent inquiry into whether there's a split in the political party. Will just take a prima facie view. So they go hand in hand. And this whole argument that you're only the legislature party, not the political party, is a completely wrong argument in law and in facts. Now, my lord, straight away to the judgments. Kindly first have, my lords, Balachand versus B.S. Yadurappa. Just give. Judgment compilation 3D, volume 3D, PDF page 25, starting at 58.
Don't want to rely upon notes straight away.
But not straight, because this is for all the judgments. I will now just 4 judgments I want to cite and would request your lordships to read with me, because that is important for.
What is that judgment compilation?
Volume 3D,
Volume 3D.
judgment compilation, PDF page 58, which is the relevant para 113.
PDF page 58.
What para did you say,
Judgments
Mr.
compilation
Kaul?
volume
113.
volume 1.
On PDF page. May I, with your lordship's permission?
Yes.
The main questions which emerge from submissions made on behalf of the respective parties and the facts of the case may be summarized as follows. A. Did the appellants voluntarily give up their membership of the Bharatiya Janata Party? B. Since only 3 days' time was given to the appellants to reply to the show cause notices, as against the period of 7 days or more prescribed in Rule 7 subclause 3 of the disqualification rules, were the said notices vitiated? C. Did the Speaker act in hot haste in disposing of the disqualification application filed by Shri B.S. Yadurappa, introducing a whiff of bias as to the procedure adopted? D. What is the scope of judicial review of an order passed by the Speaker under para 21A of the 10th schedule to the Constitution, having regard to the provisions of Article 212 thereof? The facts of the case reveal that the appellant, along with Shri MP Renukacharya and Shri Narsimha Nayak, wrote identical letters to the governor on 6/10/2010, indicating that as MLAs of the Bharatiya Janata Party, they had become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa. According to them, there was widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery in the functioning of the government headed by Chief Minister Shri Yadurappa, and that a situation had arisen when the governance of the state could not be carried on in accordance with the provisions of the Constitution. Accordingly, they were withdrawing their support and from their support from the government, headed by Shri Yadurappa, with a request to the governor to intervene and to institute the constitutional process as the constitutional head of the state. The Speaker took the view that the said letter and the conduct of the appellants in moving from Karnataka to Goa and other places and issuing statements both to the print and electronic media regarding withdrawal of support to the BJP government led by Shri Yadurappa, and the further fact that the appellants are said to have negotiated with Shri H.D. Kumaraswamy, the leader of the state Janata Dal, and its members regarding the formation of an alternative government, was sufficient to attract the provisions of para 21A of the 10th schedule to the Constitution. It was held by the Speaker that in the absence of any denial to the allegations made by Shri K.S. Eswarappa, the state president of the BJP, the same had to be accepted as having been proved against the appellants. In this regard, the Speaker referred to the views expressed by the Constitution bench in Kehoto Holohorn, wherein one of the issues which had been raised and decided was the act of voluntarily giving up the membership of a political party may be either express or implied. Even greater emphasis was laid on the decision in Ravi S. Nayak, wherein it was observed that there was no provision in the 10th schedule which indicated that till a petition signed and verified in the manner laid down in the Civil Procedure Code for verification of pleadings was made to the chairman or speaker of the House, he did not get the jurisdiction to give the decision as to whether a member of the House had become subject to disqualification under para 21A of the 10th schedule or not. The aforesaid view taken by the speaker has to be tested in relation to the action of the members concerned of the House, and it has to be seen whether on account of such action a presumption could have been drawn that they have voluntarily given up their membership of the BJP, thereby attracting the provisions of para 21A of the 10th schedule. In the instant case, the appellants had in writing informed the governor on 6/10/2010 that having become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa, they had chosen to withdraw support to the government headed by Shri B.S. Yadurappa, and had requested the governor to intervene and institute the constitutional process as the constitutional head of the state. The said stand was re-emphasized in the replies to the show cause notices submitted by the appellants on 9/10/2010, wherein they had inter alia denied that their conduct had attracted the vice of defection within the scope of 21A of the 10th schedule. In their said replies, the appellants had categorically indicated that nowhere in the letter of 6/10/2010 had they indicated that they would not continue as members of the legislature party of the BJP. On the other hand, they had reiterated that they would continue to support the BJP and any government formed by the BJP headed by any leader other than Shri B.S. Yadurappa as the chief minister of the state. They had also reiterated that they would continue to support any government headed by a clean and efficient person who could provide good governance to the people of Karnataka according to the Constitution of India, and it was only to save the party and government and to ensure that the state was rid of a corrupt chief minister that the letter had been submitted to the governor on 6/10/2010. At this point, let us consider the contents of letter dated 6/10/2010, written by the appellants to the governor, which has been reproduced hereinbefore. The letter clearly indicates that the author thereof, who had been elected as an MLA on a Bharatiya Janata Party ticket, having become disillusioned with the functioning of the government headed by Shri B.S. Yadurappa, on account of the widespread corruption, nepotism, favoritism, abuse of power, and misuse of government machinery, was convinced that a situation had arisen in which the governance of the state could not be carried on in accordance with the provisions of the Constitution, and Shri Yadurappa had forfeited the confidence of the people. The letter further indicates that it was in the interest of the state and the people of Karnataka that the author was expressing his lack of confidence in the government headed by Shri Yadurappa, and that he was accordingly withdrawing his support to the government headed by Shri Yadurappa with a request to the governor to intervene and institute the constitutional process as the constitutional head of the state. Although Mr. Sorabji was at pains to point out that the language used in the letter was similar to the language used in Article 356 of the Constitution, which according to him was an invitation to the governor to take action in accordance with the said article, the same is not as explicit as Mr. Sorabji would have us believe. The constitutional process, as hinted at in the said letter, did not necessarily mean the constitutional process of proclamation of President's rule, but could also mean the process of removal of the Chief Minister through constitutional means. On account thereof, the Bharatiya Janata Party was not necessarily deprived of a further opportunity of forming a government after a change in leadership of the legislature party. In fact, the same is evident from the reply given by appellant 9 reply given by the appellants on 9/10/2010 in reply to the show cause notices issued to them, in which they had re-emphasized their position that they not only continued to be members of the Bharatiya Janata Party, but would also support any government formed by the Bharatiya Janata Party, headed by any leader other than Shri B.S. Yadurappa as the Chief Minister of the state. The conclusion arrived at by the Speaker does not find support from the contents of the said letter of 6/10/2010, so as to empower the Speaker to take such a drastic step as to remove the appellant from the membership of the House. Now kindly have, my lords, para 142, page 64. My lords, have para 142.
Yes.
On the very same day, that is 6/10/2010, Shri Yadurappa, as the leader of the Bharatiya Janata Legislature Party, in the Legislative Assembly, filed an application before the Speaker under Rule 6 of the Disqualification Rules 1986, being Disqualification Application number 1 of 2010, for a declaration that all the 13 MLAs elected on BJP tickets, along with 2 other MLAs, had incurred disqualification in view of the 10th schedule of the Constitution. Immediately thereafter, on 7/10/2010, the Speaker issued show cause notices to the aforesaid MLAs, informing them of the disqualification application filed by Shri B.S. Yadurappa and informing them that by submitting letters to the Governor, withdrawing support to the government led by Shri Yadurappa, they had violated para 2(1)(a) of the 10th schedule to the Constitution and were therefore disqualified from continuing as members of the House. The appellants were given time till 5 p.m. on 10/10/2010 to submit their objections, if any, to the said application. Even if, as held by this court in Dr. Mahachandra Prasad Singh, Rule 6 and 7 of disqualification rules are taken as directory and not mandatory, the appellants were still required to be given a proper opportunity of meeting the allegations mentioned in the show cause notices. The fact that the appellants had not been served with notices directly, but at the same were pasted on the outer doors of their quarters in the MLA complex, and that too without copies of various documents relied upon by Mr. Yadurappa, giving them 3 days' time to file the said notice to file reply to the said notices, justify the appellant's intention that they had not been given sufficient time to give an effective reply to the show cause notices. Please have then para 147 on page PDF 66. 147. May I, my lords?
Yes.
The procedure adopted by the Speaker seems to indicate that he was trying to meet the time schedule set by the Governor for the trial of the strength in the Assembly, and to ensure that the appellants and the other independent MLAs stood disqualified prior to the date on which the floor test was to be held. Having concluded the hearing on 10/10/2010 by 5 p.m., the Speaker passed a detailed order in which various judgments, both of the Indian courts and foreign courts, and principles of law from various authorities were referred to on the same day, holding that appellants had voluntarily given up the membership of the Bharatiya Janata Party by their acts and conduct, which attracted the provisions of para 2(1)(a) of the 10th schedule of the Constitution, whereunder they stood disqualified. The vote of confidence took place on 11/10/2010, in which the disqualified members could not participate, and in their absence, Shri B.S. Yadurappa was able to prove his majority in the House. Unless it was to ensure that the trust vote did not go against the Chief Minister, there was no conceivable reason for the Speaker to have taken up disqualification application in such a great hurry. Although in Dr. Mahachandra Prasad Singh, this court held that the disqualification rules were only directory and not mandatory, and that violation thereof amounted to only procedural irregularities and not violation of a constitutional mandate, it was also observed in Ravi S. Nayak that such an irregularity should not be such so as to prejudice any authority who is affected adversely by such breach. In the instant case, it was a matter of survival as far as the appellants were concerned. In such circumstances, they deserved a better opportunity of meeting the allegations made against them, particularly when, except for the newspaper cuttings said to have been filed by Shri Yadurappa, along with the disqualification application, there was no other evidence at all available against the appellants. As
67.
then please have
150.
para 151 at PDF, page 67. This is important.
You can come to 152.
Also on the same page.
Yes.
Well, it's para 152. We cannot lose sight of the fact that although the same allegations as were made against the appellant Shri Yadurappa were also made against Shri MP Renukacharya and Shri Narasimha Nayak, their retraction was accepted by the Speaker despite their views expressed by them, submitting that upon submitting the letter withdrawing support to the BJP government led by Shri Yadurappa, all the MLAs stood immediately disqualified under para 2(1)(a) of the 10th schedule to the Constitution, and they were accordingly permitted to participate in the confidence vote for reasons which are not required to be spelled out. Then para 154. Having considered all the different aspects of the matter and having examined the various questions which have been raised, we are constrained to hold that the proceedings conducted by the Speaker on the disqualification application filed by Shri B.S. Yadurappa do not meet the twin tests of natural justice and fair play. The Speaker, in our view, proceeded in the matter as if he was required to meet the deadline set by the Governor, irrespective of whether in the process he was ignoring the constitutional norms set out in the 10th schedule to the Constitution and the disqualification rules 1986, and in contravention of the basic principles that go hand in hand with the concept of fair hearing. As we have earlier indicated, even if disqualification rules are only directory in nature, even then sufficient opportunity should have been given to the appellants to meet the allegation level against them. And kindly now have, my lords, the last para, 157, on same page. The appeals are therefore allowed. The order of the Speaker dated 10/10 2010, disqualifying the applicants on the membership of the House under para 21A of the 10th schedule of the Constitution is set aside along with the majority judgment delivered in writ petition so-and-so and the portions of the judgment delivered so-and-so concurring with the views expressed by Honorable the Chief Justice upholding the decision of the Speaker so-and-so filed by so-and-so. Consequently, the disqualification application filed by B.S. Yadurappa is dismissed. So, my lords, a much worse case, a case where the chief minister in question from the same party, they say they have no faith. But they said, where have they said that they are leaving the political party, they are forming a new political party, they continue to support the party. Thus, the extreme conclusion drawn to say that this ex facie attracts 21A is wrong. Because, my lords, if this is going to become the basis of 21A, that I express dissent within the party, then internal dissent, which is the bedrock of democracy and parliamentary democracy, will completely be thrown out of the window. Because at the end of the day, the moment anyone within a party expresses dissent, you say it's a 21A case. So in a much worse case, they said this is not a 21A case. And my lords, I'm not for a minute suggesting, as my lord the Chief Justice said yesterday, my argument is not that the majority within a party cannot attract the 10th schedule. The majority within a party can also disobey a whip or, for whatever reasons, floor cross or align with the opposition party, go to the governor for falling of the government. That's not my case at all. My case is that to determine who is the rival faction under para 15 of the symbols order, there is an exclusive jurisdiction in the Election Commission of India, which looks at the parameters as set by your lordships on Sadiq Ali downwards to see which is the rival faction within the political party to be recognized. And my case right through has been that the legislature party and the political party go hand in hand. You are today seeking to draw an artificial distinction between a legislature party and a political party to say that you have shown nothing in the political party, you've only shown the legislature party. Whereas the legislature party definitely reflects the political authority of the political party as well. In any case, as far as competent body is concerned, it has come to a conclusion that we represent within the Shiv Sena, the recognized Shiv Sena today. So my case is not that a majority cannot incur under 21A. My case is in the facts of the case. For you to say this was only legislature party and not political party is without any basis. In any case, the speaker has to decide it. You want to bypass the whole route and come to the Supreme Court in an Article 32 and say the Supreme Court must decide before the speaker, which is in the teeth of Kyoto. And my coming under a 32 was on Nabam, which is on an entirely different footing. That was the argument. Next, my lords, kindly have volume 3D, PDF 787 at page 815. Same volume I did. That's right.
क्या page? 787.
Yes.
I guess 787.
I'm running against time. And 20, but I'd only trouble your lordships with one para since there's less time. Para 19.
Page?
815. Lordships may later see both the paras 19 and 20, but I'll only read 19. My lords have 19. The Constitution is not an ephemeral legal document embodying a set of legal rules for the passing hour. It sets out principles for an expanding future and is intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Therefore, a purposive rather than a strict literal approach to the interpretation should be adopted. A constitutional provision must be construed not in a narrow and constricted sense, but in a wide and liberal manner so as to anticipate and take account of changing conditions and purposes so that a constitutional provision does not get fossilized but remains flexible enough to meet the newly emerging problems and challenges. The reason I'm citing this judgment, my lords, is in the context of Nabam, where it was said that the Constitution doesn't provide. As far as this, when does the notice period start? The Constitution does not provide for it at all. But some provision will have to be looked at. If a situation emerges when the Constitution was drafted and there was no 10th schedule to it at that stage, and a problem arises today, why can the court not interpret it in a liberal manner to take care of the fact that the constitutional values are protected? Right, Manoj? Now please have straight away of 956. This is 14.
तो बहुत पुरानी।
At 946 at 956.
You're referring to the separate volume?
Which one?
Judgment compilation volume.
Judgment compilation, volume 2, serial number 3.
946.
Yes. Which is at 956. Para 14.
This is Kuldeep Nair.
In the meantime, starts with in the meantime, my lords. That's
You referring
Kuldeep Bishnoi, my lords.
sorry.
Speaker Haryana Vidhan Sabha versus Kuldeep Bishnoi.
volume
Page?
2, what page did you say, Mr. 56?
At 9.
My lords, 946, the judgment starts. The para starts at 956.
Yes.
I'm sorry, I have the wrong volume. Just give me a moment. Judgment
Give my-
compilation.
Give
volume
my
two.
judgments compilation
Two.
2, huh?
It's serial number 3 of what?
Judgment compilation volume 2.
2. Judgment compilation, volume 2, serial number 3.
This is Kuldeep Bishnoi. No?
That's right. That's right. 946, it starts at 950.
1 second. Huh?
950.
Seem to have
Till let's see.
gone to Devinder Pal Singh Bullar.
52.
It starts
Huh?
at serial number, it's part 2. It's
Well, it's the
2000.
bookmark 52.
bookmark 52.
Judgments
Very
compilation
got
2,
it.
na?
Thank you.
390,
Nah,
yes.
got it.
अच्छा 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 sorry sorry no sorry I मेरी गलती हो गई
Kuldeep.
actually
It's 52 in the bookmarking, isn't it? Is
Thank
it
you very
Deep
much.
Singh Bishnoi? Right. 2015 12 SCC 381. Mr.
yes
Well, even if I'm not legally sound, I'm trying to sound technically correct by pointing out all the bookmarks.
No, that's good.
Your Lordship.
You're making progress.
I'm inviting upon myself, Your Lordship. Would Your Lordship be kind enough to have para 14? Yes. In the meantime, proceedings before the Speaker continued, and since the same were not being concluded in terms of the assurances given, the division bench of the High Court directed the Speaker to file an affidavit on or before 11/11/2011. Finally, being dissatisfied with the progress, the pending disqualification petitions before the Speaker, the division bench took upon the letters patent appeals on 2/12/2011 when the directions are given to the production of the entire records of the matters pending before the Speaker. On 7/12/2011, the relevant records of the proceedings before the Speaker were submitted to the High Court, which adjourned the matter till 19/12/2011 for further consideration. However, as alleged on behalf of the appellants, the bench was not constituted on 19/12/2011, and without any further hearing or giving an opportunity to the Speaker's counsel to make submissions on the status report, the High Court proceeded to pronounce its judgment on the letters patents appeals. By its judgment, which has been impugned in these proceedings, the division bench held the direction of the learned single judge directing the Speaker to decide the disqualification petitions within a period of 4 months. However, while disposing of the matter, the division bench stayed the operation of the order passed by the Speaker on the merger of the So it also declared 5 MLAs who have filed separate appeals before this court as being unattached members of the assembly with the right to attend the session only. It was directed that they would not be treated either as part of INC or HJC party, with a further direction that they would not hold any office either. It is aforesaid directions and orders which have resulted in the filing of several special leave petitions before this court by the Speaker and 5 MLAs. As a consequence of the order of the Speaker, passed by the division bench of the High Court, the 5 independent appellants before us have been prevented from discharging their functions as members of the Haryana Vidhan Sabha even before the disqualification petition filed against them by Shri Kuldeep Bishnoi could be heard and decided. Then para 46, my lords, on page 965. Last para on that page, para 46. My lords have that? The appeal filed by the Speaker of the Haryana Vidhan Sabha against the judgment of the division bench of the High Court is not therefore capable of being sustained, and the appeals filed by the Speaker is accordingly dismissed. The other appeals preferred by the 5 disqualified MLAs have therefore to be allowed to the extent of the directions given by the learned single judge and endorsed by the division bench that 5 MLAs would stand disqualified from effectively functioning as members of the Haryana Vidhan Sabha till the Speaker decided the petitions regarding their disqualification within a period of 4 months. In our view, the High Court has no jurisdiction to pass such an order, which was in the domain of the Speaker. The High Court assumed the jurisdiction which it never had in making the interim order, which had the effect of preventing 5 MLAs in question from effectively functioning as members of the Haryana Vidhan Sabha. the direction given by the learned single judge to the Speaker as endorsed by the division bench is therefore upheld to the extent that it directs the Speaker to decide the petitions or disqualification of the 5 MLAs within a period of 4 months. The said direction shall therefore be given effect to by the Speaker. The remaining portion of the order disqualifying the 5 MLAs from effectively functioning as members of the Haryana Vidhan Sabha is set aside. The said 5 MLAs would therefore be entitled to fully function as members of the Haryana Vidhan Sabha without any restrictions, subject to the final decision that may be rendered by the Speaker in the disqualification petitions filed under para 6 of Schedule 10 of the Constitution. Now, my lords, this is of course the same principle as in continuation with Shivraj Singh Chauhan, which I had read out to your lordships.
Yes.
And there was a question that your lordships had put to me on the day before yesterday, that could someone say that Shivraj Chauhan was only on resignation. That's why I read out those paragraphs that Shivraj Singh Chauhan, your lordships don't just deal with resignation of MLAs. Your lordships categorically in paragraphs 78 to 81 talk about disqualification petition under the 10th schedule. And say if disqualification petitions under the 10th schedule are pending, doesn't mean in the meantime they will stop discharging their functions as a member of the House. My next judgment for your lordships' kind consideration, my lords, is Rajendra Rana.
That would be judgment's compilation.
Judgment, no, my lords, now on a point that I'm relying on. Till now, I distinguished on what they were relying on. They were relying on it for two purposes: ex post facto, and that your lordships as a court of first instance can decide. Ex post facto, I explained to your lordships saying that it was qua the Speaker, that the events to be seen by him were on the day when they incurred disqualification, not subsequent events or split. And as far as your lordships deciding as a court of first instance was on an issue where it had been there in the High Court for 3 years, then the High Court remanded it back. When it came to the Supreme Court said the assembly election, the term is to expire by the end of the year. So let's decide the matter. That is quite different from this matter in every which way. Now, my lords, kindly have Judgment Compilation Volume 1, bookmark 19, page 834. Context of that exposed for these two. Para 25 on page 855. My lords, before I start, let me tell your lordships the context why I am citing this judgment.
Para 25. PDF 855.
My lord, the Chief Justice.
Yes.
My lords, the reason I am citing this judgment is that in this, at that time, para 3 as a defense was available. At that time. Even when para 3 as a defense was available, the Supreme Court said that the Speaker deholds disqualification, does not embark on an independent inquiry to find out about splits in the political party. He only takes a limited prima facie view of the split within the political party. The reason I'm citing is even when, this is not a question of split, this is not a question of merger, but even where it was a question of split and para 3 was still on the statute book, the court said the Speaker will not embark on an independent inquiry into splits in the political party. Please have para 25 for a minute, my lords, on page 855.
It is only a jurisdictional fact for him to enter to give a finding with respect to disqualification.
Grateful. Grateful. That's all. I couldn't have put it better. That's all. My lords, may I?
Yes.
Yes.
25. In the context of the introduction of sub-article 2 of Article 102 and Article 191 of the Constitution, a proceeding under the 10th schedule of the Constitution is one to decide whether a member has become disqualified to hold his position as a member of the Parliament or of the Assembly on the ground of defection. The 10th schedule cannot be read or construed independent of Article 102 and 191 of the Constitution and the object of those articles. A defection is added as a disqualification, and the 10th schedule contains the provisions as to disqualification on the ground of defection. A proceeding under the 10th schedule gets started before the Speaker only on a complaint being made that certain persons belonging to a political party had incurred disqualification on the ground of defection. To meet the claim so raised, the members of parliament or assembly against whom the proceedings are initiated have the right to show that there has been a split in the original political party and then they form one-third of the members of the legislature party, or that the party is merged with another political party and hence para 2 is not attracted. On the scheme of Article 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the Speaker seeking a disqualification of a member or members concerned. It is therefore not possible to accede to the argument that under the 10th schedule to the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule to the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But this is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question. He was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of para 6 subclause 1 of the 10th schedule to the Constitution, and that even if it did, the power of judicial review recognized by the court in Kehoto Holohon is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as a part of disqualification of a member of the House. That disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10th schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10th schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10th schedule or the rules made thereunder do not contemplate the Speaker embarking upon an independent inquiry as to whether there has been a split in the political party or there has been a merger. Therefore, in the context of 102 and 191, the scheme of the 10th schedule to the Constitution, we have no hesitation in holding that the Speaker acts under the 10th schedule only on a claim of disqualification being made before him in terms of para 2 of the 10th schedule. And now, my lords, kindly read this with para 37, and then I'll come back to one more para I need to show. Please first have para 37. PDF page 862, my lords. That's the last one. My lords have para 37.
Yes.
Thus, in the above decision, it has been clarified that it is not enough that a claim is made on a split in the original party, in addition to showing that one-third of the members of the legislature party have become out of the party, but it is necessary to prove it at least prima facie. They say prima facie, yes, but all the time emphasizing on this whole thing that the Speaker will embark upon a full-fledged inquiry into the political party, the talukas, the districts, and decide on a split in a political party is without jurisdiction. Quite apart from the fact that you're seeking to draw an artificial distinction which does not exist. And I'll come to that judgment. That para of Sadiq Ali, I'll show to you, lords, which is important for this. Now, my lords, kindly have, only for that other issue of ex post facto, I'll just sum it up on para 34 of the same judgment. I just need to show that.
Here comes the test. The test is here.
Yes. 860. 860. Para 34. My lords have that?
Yes.
As we see it, the act of disqualification occurs on a member voluntarily giving up his membership of a political party or at the point of defiance of the whip issued to him. Therefore, the act that constitutes disqualification in terms of para 2 of the 10th schedule is the act of giving up or defiance of the whip. The fact that a decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislator. Similarly, the fact that the party could condone the defiance of a whip within 15 days or that the speaker takes decision only thereafter in those cases cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. Therefore, in the background of the object sought to be achieved by the 52nd Amendment of the Constitution and on a true understanding of para 2 of the 10th schedule with reference to other paragraphs of the 10th schedule, the position that emerges is that speaker has to decide the question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies the whip. It is really a decision ex post facto. It is in this connection that the observation is made that subsequent facts of split, seeking a defense of split under the 10th schedule will not be looked at. You will see on the day you went to meet the governor in the facts of this case, some of the MLAs with the opposition party and asked the Samajwadi party to form the government was an act which was squarely hit by 2-1A. And that is why, my lords, I had respectfully submitted and read out instances of Ravi Nayak of this judgment. They were overt acts under 2-1A. Yadurappa's judgment clearly says merely because within the party I say I do not support a particular coalition of a government is not a 2-1A case at all in the matter. In any case, my lords, who will decide it? Whether it's a 2-1A case or a 2-1B case, it still has to be the speaker under para 6 who's the sole and exclusive constitutional authority to decide it. So A, I'm not a 2-1A case. B, Yadurappa is held merely because you show support to a government is not a 2-1A case. And thirdly, my lords, in facts of these cases, the facts which have to be seen are the facts on that date. The ex post facto is in that context. Ex post facto doesn't mean that since your disqualification will be decided on the date you incurred it, all your acts as members of parliament or members of the legislative assembly get annulled in the process. And that is the deduction sought to be drawn now from the words ex post facto in Rana's judgment. Now, my lords, kindly have, just last two judgments and I'm done, kindly have Rameshwar Prasad versus Union of India. Same volume, bookmark 16, para 165. Relevant para 165 is at page 521.
What's the, sorry, page?
PDF page.
Page 520.
PDF page 521.
Same compilation.
Same volume,
PDF is 390.
521. My lords have para 165. May I, my lords?
Yes.
If a political party with the support of other political party or other MLAs takes a claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. Governor is not an autocratic political ombudsman. If such power is vested in the governor or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power of 356. Remedy for corruption or similar ills or evil lies elsewhere and not in Article 356. In the same vein, it has ought to be held that power under 10 schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature, dealing with question whether power of disqualification of members of the House vests exclusively with the House to the exclusion of the judiciary, which in Britain was based on certain practices of the legislature. As far as concerned, it was said in Quixote, it is therefore inappropriate to claim that determinative jurisdiction of the Speaker or the Chairman of the 10th schedule is not a judicial power, is within the non-justiciable legislative area. So the reason I'm citing this judgment, my lords, is for the fact that for A, of course, we say that the Chief Minister lost his majority, the coalition government could not survive. We within the party were the overwhelming majority. And even if their argument was to be accepted, which I'm not conceding, that, oh, you cobbled it up together in an illegal mean, etc., which it is not. It was a perfectly legitimate government which was sworn in. The governor is not to sit on these matters and make his assessments if a probable, plausible coalition or partnership comes before it and says, because ultimately at the end of the day, someone has to head a government, my lords. My lord, the Chief Justice posed a question to me yesterday. After the sitting Chief Minister resigns, someone has to be sworn in. Now, if a set of people come and show that they have a sizable or an overwhelming majority, he says, go and test it on the floor of the House. And what time does he give? 2 days to do it. And your lordships have normally said those cases where you're given a month, 2 months, and that is scope for horse trading, etc. He immediately calls for a floor test in exercise of his constitutional duties and obligations and say, prove your majority. If you are the new government which is taking its claim within the same political party, now in coalition with another political party who's a pre-poll ally, what is wrong with that decision of the governor within 2 days? Now, my lords, kindly have lastly, Sadiq Ali for a completely different proposition. Volume 2, bookmark 39,
Same volume.
PDF 85 at 98. Can we repeat that?
Yeah.
Volume 2,
Bookmark 39
bookmark 39.
starts at PDF page 85.
The judgment starts at page PDF 85.
Relevant para at PDF 98.
Relevant para at PDF 98.
Para?
98. Para 27, page 98. Well, before I proceed to read, my lord, the Chief Justice, can I? Before I proceed to read the judgment, my lord, the reason I'm citing it is I right through said, apart from all other arguments, that you cannot segregate the two. One of the principal arguments for recognition of a political party under 6A and 6B of the symbols order, those provisions I have not read, of 6A and 6B for a continued recognition. And recognition of a political party is the number of percentage of votes polled by MLAs, MPs, its strength in the House. These are all relevant factors. So what happens in the legislature can't be just kept aside. That's a relevant consideration within it. So to say that they're two completely distinct things and political party is distinct and legislature party is distinct is not correct. And that is what Sadiq Ali also notices in this paragraph, is what I wanted to show it for. The other paras, my lords, I'm not bothering your lordships on all those powers of the EC because we are not getting into that. It may be mentioned that according to para 6 of the symbols order, one of the factors which may be taken into account in treating a political party as a recognized political party is the number of seats secured by that party in the House of People or the state legislature assembly, or the number of votes polled by the contesting candidate set up by the such party. The number of seats secured by a political party or the number of votes cast in favor of a candidate of a political party can be a relevant consideration for recognition of a political party. One is at a loss to understand as to how number of seats in parliament and state legislatures held by supporters of a group of political party can be considered to be irrelevant. We can consequently discover no error in approach of the Commission in applying the rule of majority and numerical strength for determining as to which of the two groups of Congress J and Congress O was the Congress party for the purpose of para 15 of the symbols order. Now, that is a separate matter which your lordships are dealing with, where this has also become one of the considerations. And this para of Sadiq Ali in that other matter that your lordships are dealing with. That this is one of the indicators, valid indicators available. So to come and say that you've only done it in the legislature party, there's nothing in the political party. And their entire argument, my lords, was, with great respect, that on 18th you had a meeting and you showed the minutes of 27th. It's factually wrong. I'll argue it there in that matter. They're two separate meetings. They're factually incorrect statements made that you had a meeting on the 18th, but there are no minutes, there are no signatures. That's not the subject matter of the reference before your lordships at all. And I'll argue it there. There are two separate meetings. Requisite members attended it. And please do not confuse the minutes of one meeting with the holding of another meeting. My lords, I'm very, very grateful. Your lordships have been extremely kind and patient. I'm extremely grateful, my lords, and the 3 notes I've given. I'm extremely grateful.
Thank you, Mr. Kaul.